Afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. Go ahead and start putting your questions in the comments as you join me. And as soon as I'm finished with the topic that I'm going to talk about, I will go ahead and address your questions. But just to make sure that I do get to your questions, start putting those in the comments so I can see them and answer them right away. Now, I have a topic, and it's going to be what causes a VAWA RFE, right? The RFE is the proper term for it is request for evidence. And the request for evidence means just that usually they have reviewed your application and they have additional questions and so or they have additional requirements that they feel that you need to meet before they can make a final decision. The request for evidence is essential that you pay attention to the deadline dates on the request, because if you miss that, it could mean that a denial will surely follow. Now, the deadline is usually listed in the RFE, or they will state a deadline in the request for evidence. They will tell you the amount of time they're giving you. Typically, if it's not stated, it's going to be 30 days. But if it is stated, you're going to have at least about 60 days, or they will give you about 60 days in some cases to provide the evidence that they need to make a decision. There were certain extensions that they provided due to COVID, and the extensions allowed individuals to add an extra 60 days to the deadline stated in the request for evidence. But as of March 23rd, that is no more of those extensions. So whatever date is in the letter, the request for evidence, is going to be the date that you have to get it back to the USCIS by, or else you could face a denial. So essential step one is to look when you get a request for evidence, look at the deadline and make sure that you work towards putting your response to the request for evidence together before then. Usually, if it's going to definitely involve more complex matters, you want to and you need to get legal assistance or legal advice. It's an urgent. Treat it with urgency, because an attorney is going to need time to review the request for evidence, to collect additional documentation if necessary, to do additional legal research, and to put together a proper legal argument to help you to get that approval. So do not sit on a request for evidence for weeks and weeks and then go last minute and expect an attorney to submit a good response, because it does. When I am dealing with the request for evidence, it does take at least a few weeks to respond to the complex request for evidence. Now, when we're talking about VAWA, why would you get a request for evidence? So initially, when they review it, so when they receive it, if they see anything that's missing in regards to required evidence, they will send a request for evidence. So for example, they may see that you didn't submit evidence of your bona fide marriage, or that you didn't submit evidence that you are married, that you have a qualifying relationship, or they may not have seen any evidence addressing your good moral character. Whenever they look at the documents you've provided, and if they see any element missing, they're going to send that to you, and which means that if you don't submit it, it's going to lead to a denial, because usually that request for evidence, it's going to the core of the requirements. And so if they're telling you that you haven't showed evidence of good faith marriage, you haven't showed proof of relationship with a qualifying relative, you haven't shown proof of good moral character, you haven't shown proof of even the mistreatment or the abuse, then that means that you need to jump on it, or you're going to face a denial, right? But say you received a prima facie determination letter. It does, while it is evidence that your case is going in a really good direction, because the prima facie, it basically is like a pre-approval. It means, we believe that you qualify if all the facts here are true and credible. We would approve it today, but we're gonna go ahead and do a more detailed review. It's sort of like applying for a mortgage where you get your pre-approval, but then once you put the offer down on the house, they are really digging in. The underwriters really dig deep in to make sure that everything lines up before they give you the final approval for for the mortgage to move forward. It's a very similar process with VAWA, is that you get this prima facie determination letter. It's comforting. It means you're going in the right direction. You can possibly use it for benefits in other states, but it does not mean that you are completely out of the woods yet. You may get additional requests for evidence. And why may that be, right? After you get the prima facie determination letter, why may they turn around now and ask you to respond to another request for evidence, sometimes years after you submitted your application, because it is backed up by about 2 to 2.5 years? So you could get that that more detailed request for evidence right before they're going to make a decision 2 years later, right? So this is all the more reason why you should make sure you have an attorney representing you through this, because that's where it can get complex. If they're digging deep into your application and they notice certain inconsistencies, that and sometimes question your credibility, the credibility of your story, the credibility of your evidence, you will get a request for evidence. So, for instance, if there is if you submitted evidence in your, say, your declaration, you say one thing about living with your spouse, but they look at your evidence of living together, residing with your spouse, and they may see an inconsistency in the evidence that you submitted versus what your statement says. They often want to clarify these types of inconsistencies in your application. So you want to make sure, and this is what we do with our clients, we make sure that where we can address any sort of differences or inconsistencies, we can explain that. We do it from the get go, right? We do it from the start. We make this petition very detail oriented so that the officer has full picture of what happened, and they're not going to come back and ask for why this is the case or why it's not the case. It doesn't, no, it doesn't mean that a request for evidence means that you're denied. And in some cases, we still can't avoid additional questions, right? But you want to make sure that you understand how to address these questions, understand that it is a situation that can be fixed. Don't think that you're going to get a denial. Don't give up on your case if you get a request for evidence, especially when it's detailed to the point where it's asking you to clarify things that may not add up, right? Where maybe you're living with your spouse, but then the evidence says otherwise, or maybe you continue to have a relationship with your spouse, but then you, in your documentation, you say that you're separated. These are aspects of the process that may raise questions, and it's okay to make sure. As a matter of fact, it's never simple, right? It's never that simple. When we're dealing with relationships like this, marriages, parent-child relationships, sometimes you continue to have a relationship with a person that's mistreating you. It's not, may not just be a situation where you continue to you end, for example, if you're in a co-parenting situation, right, where the kids may not be abused, but you were mistreated, that could explain why you continue to have a relationship with the spouse. You may continue to have a romantic, intimate relationship with your spouse, but you may not be physically living with them anymore. That is okay, right? It's just that some of these questions may be raised in the request for evidence, and you want to make sure that you address those. Now, for me, when I'm addressing questions like this is where I use case law, I use statute to be able to address these questions, right? For example, if they said you never really you never proved your bona fide marriage, that you entered the marriage in good faith. Well, you only need to show credible evidence of a good faith marriage. And so the question is, are they holding you to a higher standard? If they're holding you to a higher standard, then that would be improper. That would be an improper application of the law. And so this is where legal representation makes a difference, because you may not understand that these are the types you can respond with the knowledge of the law, detailed knowledge of the law, and still turn your case around. For example, when sometimes they don't even look at the evidence, sometimes they overlook evidence, and it's a matter of resubmitting and explaining that the evidence is there and perhaps clarifying that evidence. It could be as simple as having the knowledge of what is a proper basis of a good faith marriage. For example, some of my VAWA clients, they already have an approved I-130 petition. That alone, attached to a VAWA petition, is evidence of a bona fide marriage, right? So, when you get these requests for evidence, make sure that you treat it with urgency, get legal representation. It does make a difference, because you're not a lawyer. You don't necessarily, you may try to address it from a factual standpoint, but that may not be enough. Maybe it's also using the facts and applying the law to the facts to make a good, solid case for yourself. That is what I do for my clients when I'm responding to a request for evidence. So those are the kinds of issues that can cause a VAWA request for evidence, right? Is where you're either missing a requirement and they want you to provide that, or they later on, after a couple of prima facie determination letters, they may have additional questions about the consistency of the facts. They may need you to explain some of your facts. Sometimes they may even try to hold you to a higher standard than they should. And this is where the law is very important in explaining, so that you're not subjected to a standard that's improper. Because for each evidence that you have to show, it's really showing any credible evidence of a good faith marriage, any credible evidence of the mistreatment or extreme cruelty, any credible evidence of your residence together at any point. So it's not going to hold you to a higher standard than that. And any credible evidence means any believable evidence. So it's very flexible. It's flexible, and that means that you can take evidence as long as it's believable. It can be argued to be evidence to get you approved for the VAWA. All right, so now that I said my piece, I'm going to go ahead and take questions. So go ahead, and I already see those questions coming in. I'm excited to answer some of those questions. So keep putting those questions in the comments as I scroll through. So here we have on YouTube, hello there, Caroline. It's so nice to see you. If you overstayed your visa, can you fly within the US? Yes, it's possible. No, it's not. Don't take this as specific advice to you, because your risk factors can be different depending on what your current. But I have plenty of clients who don't have a current, and they're able to fly around the United States. So, do you, a lawyer, get an RFE before the actual letter in the mail? So it's rare, but in some cases, an attorney may get the letter by the RFE by email, just depending on is it a specific officer that got in touch with the lawyer, maybe it got lost and the lawyer submitted a request for it, especially via the when we're dealing with VAWA, where we communicate sometimes by email. But most times they are going to send it by mail. They resend a request for evidence by mail. But if it's an urgent situation, or if it's sometimes after an interview, the officer will directly send that by email to the attorney upon on request. If you don't have any criminal history other than overstay, is it safe to travel on AP through VAWA to your home country? I say that while while I can't give you specific legal advice that it is safe because I'm not your attorney and I have not worked on your case. What I can say is that whenever I have my clients and they have no additional risk factors, no past criminal history, no past immigration violations, serious immigration violations other than an overstay, then I usually tell them it's fine to go ahead and travel. However, in regards to you, I wouldn't be able to tell you because what I do for all my clients is when they're about to travel, I let them know they need to tell me so that we can, review their case, make sure everything is good to go before they leave the country. Uh, all right. Thanks for your patience as I go through the questions here. Can you elaborate on the B1, B2 new ruling regarding getting a job? So I'm not sure what that new ruling is regarding the visitor's visa. I'd have to look at that. Good morning. If your fiance owes child support, just got their citizenship, will there be an issue if you go to visit them on the B1, B2? So it shouldn't reflect on you. So if you have your B1, B2, and you're going to visit your citizen fiance in the United States, that should not go against you. Them having child support should not go against you. Now, if they're going to sponsor you, then, not necessarily having child support, but being able to make enough to support their children it may be an issue. The charge is with a patron in McDonald's restaurant, but the X charge is not finalized, but it's possible. So I'm not sure what that is. If your husband refuses to give you specific documents to file your application for change of status, what would you recommend doing? Go ahead, schedule a consultation with me, and let's talk about why that's happening. If it's happening because your spouse wants to maintain control of you, they want to use your immigration status against you, they want to keep you undocumented here, they want to keep you to overstay and then keep you undocumented here because they find that's the best way to control you, that means that you could qualify for VAWA. And that could be an option where you don't have to go through the spouse that's refusing to allow you to gain legal status here, but it could go where you have your own process in place. And this is confidential too. This will not be disclosed to this spouse. And what we do is I, as the attorney, I make sure I work with my clients to correspond with the USCIS directly so it does not go to the shared address with the spouse. Of course, I do say always be safe, prioritize your, but we take steps to keep our clients safe. So, that could be a potential option, but I don't know, other than your spouse refusing to give you specific documents, what else is going on? What else is going on there? Let me know if you can hear me. Let me know. Okay, I'm seeing likes. I'm thinking my audio did not go away. Hmm. All right. So I'm scrolling through to see more questions. Um, so I saw that. So my husband moved out and leave me. We've been living together for 2 years. I just came home, realized he moved out. Is this good for VAWA case since this is abandonment? Go ahead, schedule a consultation. Abandonment can certainly be one of the major warning signs for me of some sort of bigger issue relating to extreme cruelty or abuse. However, abandonment by itself does not necessarily mean that you'd qualify, but it's one of those, whenever there's abandonment, there were larger, bigger problems going on, a pattern of mistreatment or extreme cruelty. So go ahead, schedule an appointment, and we can talk more about your facts to determine whether this can be a VAWA case. So go ahead, schedule a consultation whenever. Keep in mind that I don't give specific legal advice on this live, and I just try to describe as much as possible what kinds of warning signs you should look out for, what kinds of behaviors against you can qualify you for VAWA, but it really is fact specific. For example, if they abandoned you, I would want to understand what else happened in the marriage that led up to the abandonment, because that's going to really paint the picture for the officers to understand exactly why this amounts to emotional abuse or extreme cruelty. So it's so important. If you are in this situation where you want to gain your own right to get permanent residence, especially after investing 2 years of your life in someone who did not have the same regard for your welfare, then this process is going to be a good option for you. So go ahead, call the office, don't wait, treat this with urgency, and get started right away. And keep in mind that whenever you have a situation like this where the spouse abandons you, they could be cooking up something on their own, right? So, for example, I have mentioned before that annulments instead of a divorce will make you no longer qualify for VAWA. And some of these spouses, they try to get a marriage annulled, which means that it invalidates your right to seek VAWA, seek the green card without to seek the green card without them. So they could be secretly doing things like this behind your back, filing for a divorce or filing for an annulment, which eventually could affect your ability to apply for VAWA. So you want to protect yourself and make sure that you understand your rights and you treat it with urgency to get it done. Um, all right. Okay, do you need a lawyer to do DACA advance parole? You're never going to catch me saying you don't need a lawyer. Because what may seem simple is not. Um, my husband is in an altercation with a patron where he felt threatened and pulled his licensed firearm. Now he got a phone call from the police officers after reviewing the video surveillance. They now want to charge him for assault. Can this affect my filing petition? So it may not. It just depends on who the victim was, who was the person that they're filing the charges, and they put as the victim in the charging document. So usually there's what's called the Adam Walsh Act, and if they feel as if if they feel as if this individual posed a harm to a minor, committed a crime against a minor, then they can that can affect the filing here. But just a criminal charge alone is not necessarily going to stop the process. Now, another thing is if they end up in jail, that could also affect their ability to attend the interview, which can lead to it can lead to a delay in your application process. How long after marriage can someone annul marriage? So, usually whenever you deal with annulment, it's either by fraud or shortly after. I'm not a divorce attorney, by the way. So you really have to talk to a divorce attorney. But usually when I've observed annulments, it's shortly after getting married, or if they can show that some kind of fraud was committed against them. Speak to a divorce attorney to determine your rights. But the point of what I'm saying is make sure you protect your rights and apply before an annulment, because if you apply after an annulment, it means you lost your chance. If an annulment is granted, you've lost your chance to VAWA. All right, so that's going to be it for me. Okay, so sound is back. Sound is back. Okay, good, good, good. Okay, so that's going to be it for me today. Time is running out and I'm hopping on to another live. So I am going to be done for today, but I'll be back tomorrow at around lunchtime where we'll continue to have a conversation. So think of those questions you want to ask and then hop on with me tomorrow and ask those questions. In the meantime, don't wait. Go ahead, schedule an appointment now so that we can go ahead and determine whether you qualify and get started right away. So no, we don't do criminal law. While we do take on clients who have criminal issues and we're able to ask for forgiveness, we do not do criminal law. So you'll have to, now a criminal lawyer is not going to be able to advise you about the immigration matter. So you can schedule the consultation to talk about the charges, to see who are the victims or victims in this case, and whether it does fall under the Adam Walsh Act, and I would be able to tell you whether it could affect your filing. All right, I'll see you all tomorrow. Bye-bye.